S14A0309, Kristen Lynn May versus the state. Wick Cawthorn for appellant, Barry Hickson for appellee.
May proceed when ready.
May it please the court, Chief Justice, my name is Wick Cawthorn, and along with Bettina Davies, I represent the appellant Kristen May in this case. I'm going to try to limit my argument to 17 minutes and reserve 3 minutes for rebuttal. There's two very complicated questions in this case, so I may have to really cut it short. Procedurally, I'd like to bring you up to speed. Appellant has been accused of failing to report child abuse pursuant to OCGA 1975. She filed a general demur and a plea in bar at trial, arguing that the state had failed to accuse her of a crime. In its order denying appellant's motions, the trial court found that the elements for failure to report a crime under 1975 were: 1, that defendant is a teacher, that defendant had reason to suspect child abuse, that defendant failed to report that abuse, and that the crime occurred in Cherokee County. Appellants here today asserting that that order and those elements are error. The trial court granted a certificate of immediate review. In an appellant's application for discretionary appeal, appellant argued that the trial court's interpretation of the statute was error and unconstitutional as applied to her. The Court of Appeals denied appellant's application, and this court granted her petition for certiorari. In your order granting cert, you instructed the parties to address two questions relating to the statutory interpretation under 1975. First, we were to address whether the statute creates a general duty to report child abuse, or whether that duty arises out of a relationship or connection with the alleged victim because of appellant's employment as a school teacher. Second, we are to address whether the state must prove that appellant knowingly and willfully failed to report by showing that the failure to report was a result of an evil purpose or a knowledge of the duty. Now, there's some relevant facts here, but they're very small relevant facts, and I want to point this out because both the trial court order and the state's brief contain an incredible amount of facts that are not properly before the court, were not in evidence, and are not relevant for the determination of the issues before this court. There's two stipulations. One is that the victim was a student in the Fulton County school system at the time of the alleged crime. And two, it has never been disputed that appellant is a teacher and was a teacher in the Cherokee County school system at the time of the alleged crime. Question 1. In order for the state to convict appellant under 1975, they must prove that she was acting pursuant to her professional duties as a school teacher at the time of the alleged crime for two reasons. First, the history and plain language of the statute show that the General Assembly's intent in enacting the statute was to require a relationship between the mandatory reporter and the child abuse victim that arose out of the mandatory reporter's duties as a mandatory reporter. Second, without that relationship, the statute violates the accused's due process and equal protection rights under the Georgia and United States Constitution. Now, this statute was enacted in 1965. House Bill number 44 in 1965, the original statute was very limited. It required medical personnel who had treated children and found that the injuries they were treating were caused by non-accidental trauma inflicted upon that child by a caretaker were required to report child abuse to the authorities. Doctors were in a position to discover abuse because of the injuries, and even in the preamble of the statute, the General Assembly noted that when an examining physician believes that the injuries were non-accidental and inflicted by caretakers, that they should report those injuries because those physicians often treat children as a result of those injuries. The General Assembly has never shown any intent to completely change the original reporting duty. The majority of the changes to the statute from 1965 all the way up through the modern version of the statute that was effective January 1st this year has exclusively expanded the number of mandatory reporters. Therefore, the General Assembly has changed specific language in the statute to make it make sense with the new categories of mandatory reporters. For example, school system employees were added to the statute in 1973, but the requirement that the mandatory reporter personally examine the victim wasn't removed until 1974. Now, the logical reason for the removal of the examination was because the categories of mandatory reporters had been introduced into the statute such that an examination no longer applied to every category of reporter, because some of those types, especially school system employees, would not be examining a victim. The requirement that this duty to report arises out of relationships still exists in the statute. Section C2 of the statute specifically predicts that these 15 classes of mandatory reporters in Section C1 will attend to a child pursuant to their duties as one of those mandatory reporters. Now, the evil that the statute seeks to repair is child abuse. It's very clear throughout the history of the statute. The remedy that the General Assembly has chosen to cure the evil of child abuse is to make certain people mandatory reporters. And why are those certain people mandatory reporters? They are mandatory reporters because they are in a special position to learn about child abuse. Why are teachers mandatory reporters but not architects? Why are podiatrists mandatory reporters but not accountants? Why are dentists and volunteers at pregnancy resource centers reporters but not electricians? And why did it start with doctors? That's because all of these categories, teachers, podiatrists, psychologists, volunteers at pregnancy resource centers, dentists, doctors, school teachers, and all of the other members of the 15 categories of mandatory reporters are likely to learn about child abuse as a result of the practice of their profession or their duties as a volunteer. They're about likely to learn about it because they treat, examine, and care for children. In 1989, this court decided Gladson v. State and Powell v. State, which dealt with an accusation on failure to report among a licensed psychologist and a psychologist under 1975. In that decision, this court in its dicta noted that there were some possible constitutional problems with this statute. The court said, and I quote, "The statute as presently drawn invites serious constitutional inquiry as to the adequacy in defining classes of persons who are required to make reports of child abuse. Here, without the status relationship, 1975 is a violation of the due process and equal protection because the categories that it makes are uncertain, vague, and arbitrary and irrelevant to the General Assembly's purpose in enacting the statute. Without the relationship created by the duty that arises out of a person attending to a child because of their duty as a member of a category, the statute violates due process. It doesn't give reasonable people the ability to discern with knowable criteria how to avoid committing a crime."
How exactly would you define the relationship that's required? The child has to be in the care or custody of the reporter?
Yes, I would say that a treating physician, an active patient-doctor relationship, an active student-teacher relationship. A child goes to school in that teacher's school. If a teacher can give a child a demerit, if a teacher can write a child up, if a teacher can give a child attention, that teacher is exercising some authority over that child and attending to that child.
I mean, you would concede, right, that the child does not necessarily have to be assigned to that teacher's class?
No, I think that the teacher would have to have some sort of power and attend to the child pursuant to their duty. There's a lot of case law in this state that shows that teachers have responsibilities to children that are in their care that aren't necessarily literally in their classroom. However, a student...
Would you say being in the same school would be enough?
Yes, I would say being in the same school would be enough. I wouldn't, in this case, we have a student that goes to a different school system entirely. The teacher appellant in this case has no different relationship with regard to the student than anyone else who happened to live in Cherokee County or happened to be near that child at that time. The teacher did not attend to the victim pursuant to her duties on the staff of a school.
But Mr. Cawthorn, you would say just being in the same school, that the student is in grade 9 and the teacher teaches in grade 10, that's enough. I mean, you would say that would be okay.
I believe that teachers that
Well,
are...
like you say, because you have, lunchroom responsibility, you have.
Yes, sir. You have the ability to maintain the hallways, tell somebody to pull their pants up or quit running or quit yelling. And teachers do that all the time to other teachers that aren't necessarily other students who aren't in their grade or in their classroom.
I mean, it wouldn't be necessarily that the relationship would always be there if the child was at the school, but you would say there's at least a jury question in those cases.
I think we have to have some objective criteria in this case, and it's not strictly, and it's mainly because school teachers are one of 15 separate categories, and some of those categories include people who volunteer at resource centers, and potentially it includes people who volunteer reading at an elementary school. So without an active duty where you have a power over the potential victim, what you've got is a nebulous quasi duty that is hard to predict. For instance, if you go read to a group of elementary school students, do you have a duty to report something that you learn while you're reading there? You probably do. Okay, but 4 weeks later, if one of those students is at the mall and you see someone punch that child, do you have a duty to report that one? I don't think you do. I think that's been severed. It's been severed because there's no longer an active duty to the child, because you're no longer, attending to the child. There's some interesting dicta as well in some Court of Appeals cases dealing with this statute, and obviously it's just persuasive dicta, but the Court of Appeals in reading the statute has almost assumed that there was a duty that arose out of the attention to the child pursuant to your profession. I'm quoting Vance versus TRC here, where the Court of Appeals said the statute imposes a duty on an extensive list of persons who in the practice of their professions are likely to discover evidence of child abuse. In Fulton DeKalb Hospital Authority versus Reliance Trust Company, the court said roughly the same thing. In Magera v. Posig, the footnote 3, the court said the statute also mandates reporting of child abuse by physicians, hospital personnel, dentists, nurses, professional counselors and social workers, teachers, guidance counselors, and certain other persons who in their professional work might see indications of abuse in the children they treat. There are 15 categories here, and there needs to be a bright line. And without this bright line duty to report, this is a nebulous law. People walking the streets don't know if they're violating the law. Does a lawyer who takes phone calls at a pregnancy resource center have a duty to report when while that lawyer is taking the phone calls at the pregnancy resource center? If a person tells them about child abuse pursuant to that duty, yes. But does that same lawyer, because they once volunteered at a pregnancy resource center, have some sort of ongoing duty to report abuse? That's not really a tenable reading of the statute. It's overly vague, and we argue it violates principles of equal protection.
Let me give you a very quick hypothetical on this point. Suppose that a second grade teacher has a student in his classroom come in and say, "Mr. Teacher, last night Daddy beat my little brother, and little brother is not yet school age." Duty to report?
I would say so, but then how did the teacher learn it? The teacher learned it because he was attending to the student pursuant to her duties as a teacher.
So it doesn't have to be a relationship with the abused child. It's the relationship with what child? How do we define the relationship?
Well, but we're splitting hairs a little bit here, but if a second grader tells you that he saw his father beat his younger brother, that second grader is a victim of abuse, because that second grader is now a victim of cruelty to children, which is a misdemeanor in this state. That's what makes simple battery into a cruelty to children. So that child who has witnessed abuse becomes himself a victim of abuse. This court also asked us to interpret the knowingly and willfully language in the statute, and I'm going to jump ahead to Section 2, and I'm sorry to jump like this, but it's the only way to get to it. The statute makes it a crime for a person who has a duty pursuant to that statute to knowingly and willfully fail to report. Now, in Fagan versus State, this court interpreted knowingly as it applied to 1612-100. And we believe Fagan stands for the premise that when a statute includes the word knowingly, it becomes an element of the offense and requires proof of scienter. The state must prove a guilty knowledge was harbored by the defendant. Here, the state must prove a guilty knowledge was harbored by an appellant. And what does that mean? That means that appellant must have been aware of the circumstances and the facts that created the crime. They must have been aware of the duty to report and failed to undertake that duty. And why must they be aware of that duty? Well, this is a duty to report that's very similar to the non-structuring provision in the Ratzlaff case that was pointed to in this court's order granting cert. In Ratzlaff, the Supreme Court dealt with a statute that made it illegal to structure transactions so as to avoid the IRS reporting requirement. The criminal portion of the statute made it a crime to violate another portion of that statute. Ratzlaff dealt with a non-criminal thing. Okay, it's not illegal to structure cash transactions. This statute as well makes normal activity criminal. It is not illegal to not report child abuse. It is perfectly legal to mind your own business, okay? There's only 15 categories of people who are required to report child abuse. And we believe that knowingly and willfully requires that those people not only must know about that duty that the statute creates, but they must willfully violate the statute, willfully fail to report. What does willful mean? Well, this court in Roby versus Newton has said that willful means with a bad intent. It means with a bad purpose. This is similar to the way that the Supreme Court dealt with willful in Ratzlaff, and it's consistent with the way that this court has always interpreted willful. We presume that if a word is in a statute, the Supreme Court, the General Assembly did not just throw it into the statute. The word is in the statute for a purpose, and I'm going to reserve the remainder of my time for rebuttal. Thank you.
Thank you. Mr. Hickson?
Thank you, and good afternoon, Mr. Chief Justice and Justices of the Court. My name is Barry Hickson, and it is a pleasure to appear here today. Picture, if you will, for a moment, a teenager, a regular kid with a normal family and friends and a school and an environment that we would probably call stable. And imagine that stability begins to shift. Mom and dad are fighting because they're getting a divorce. The teenager has to go to a different school to live with what we call a primary physical custodian. She gets mixed up with some of the wrong people. She becomes vulnerable. She tries some things she shouldn't have, things that are unfortunately very available these days. And then she consents to something that in retrospect is so terrible that she can't even think about it. It keeps her up at night, fretting and crying and wondering, what am I going to do with this? Where can I turn? Who will help me? And then, like a prodigal son or daughter, she comes to herself and she says, I know where I can go. I know who will help me. My teacher. My teacher will help me.
Former teacher, right?
Yes, but to this particular teenager, she's the teacher, the one she trusts. She is a former teacher, Your Honor, but she's the one that the student, who is a student and is known to the teacher, chooses to unburden herself to. And so she returns to the school that she left just a few weeks before, and she seeks the teacher out at a sporting event on school property in the gymnasium and surrenders this crushing burden. And instead of helping, instead of giving aid or comfort or sounding an outcry, the teacher says, in effect, I don't know you. Depart. You're somebody else's student.
Are you going to get to the
Yes.
legal issues?
Yes, I am. Yes, I am.
As far as I know, all of the facts you've just kind of hypothetically said are not before us, because the only facts that are stipulated to are the ones he mentioned.
Well, I think there was a proffer of facts made before the trial court by both the state and the defendant, and that they became part of the trial court record. They were the facts which the state sought to prove at trial on its accusation. But
It sounds like where you're going is, because this was a person she turned to, and because this person has a reporting requirement, ipso facto, she has a reporting requirement as to this child. Let's say she had turned to you, a respected member of the bar, someone with a reporting requirement as an attorney, an upstanding citizen, and her closest and best adult friend in the whole world. But you have no legal connection with her whatsoever. Is it your view that you would have a reporting requirement under the statute?
yes, because I'm in law enforcement. Yes.
Okay, what if it were her best friend is her uncle, who is a doctor from New York, who happened to be visiting Georgia, has never treated her, just is actually a family member, and she confides in her uncle, the doctor from New York. Does he now face misdemeanor punishment in Georgia because he didn't report?
I don't believe so, because the report is not made in connection with his status as one of the enumerated classes in Georgia. I think the thing that is easy to overlook in this case is that when this teacher acquires this knowledge, the harm involved here, which the legislature is trying to prevent, is not just about this student who transferred a few weeks ago. What the teacher learns is that there's a fox loose in the chicken pen. There are other students that are in the immediate care and control of this teacher, and the person that's been suggested as the predator is among them. It's not simply about this student and this teacher, it's about this teacher and these students. And
How do you explain the language of the statute that says in C2, that says that if you're required to report abuse pursuant to this subsection because you attend to the child pursuant to your duties as a member of the staff of a hospital or school, then you have to notify the head of that institution. But it uses the terms attend to and pursuant to your duties.
it does, Your Honor.
Are you saying that the defendant teacher had a duty as a member to that child who was no longer in the school system?
Yes, I'm saying she had a duty to that student and to other students in the school where
It's not other students, it's a duty to, it's a duty to a child. It's not some random child, it's the child at issue in the reporting.
But, Your Honor, it doesn't say the child, it says
well,
a child.
well, there's
It
no-
says a child.
Well, did the person who told this teacher something tell her about any other abusive children?
No, but she told her who did it. And who did it works in that teacher's school and has other students that this teacher has.
So she had a legal duty to the child?
She had a legal duty in general to report to the principal what she'd heard. That's my interpretation.
And if she, for example, negligently tripped the child and she fell down, would the school system be liable because she had acted as a teacher toward the child? Or would she be acting as a citizen toward the child?
I don't think this is a negligence statute.
No, but the statute uses the term duty. Duty is normally established in a legal relationship. If you want it to be a duty, if you want teachers to have duties to students they used to teach, then it's hard to say they have a duty to those students only for this statute and not in general.
I see what you're getting at, and I'm not sure that I would be willing to say that a teacher has the duty to report as to every former student. There must be a point, I agree, where a teacher becomes a discretionary reporter rather than a mandatory reporter.
And where is that point?
It's certainly not here. There's some language from the case that my brother cited right at the end of the Gladson opinion, where the court said that in this case, even if the outermost boundaries of the applicable section of the ordinance may be imprecise in some situations, we need not make that determination, as defendant's conduct clearly falls within the hard core of the ordinance's prescription. And I believe that's the sort of case that we have here. This isn't a close call. This is exactly the kind of case where the legislature expects to hear an outcry, because
I would think exactly the kind of case where the legislature expected there to be an outcry is when a child who is assigned to that teacher comes into class and discloses child abuse. I would think that's the heartland case. I would think this is more on the periphery.
well, I would agree that Your Honor's hypothetical is closer to the bullseye, but the appellant in this case has acquired knowledge or reasonable suspicion of a danger in the school, to students in the school, from a person in the school, from a student who recently was her teacher.
But she acquired it as a friend. She didn't acquire it in any student-teacher relationship.
She would never have acquired it had she not been known by the student as her teacher.
Okay, so a doctor who treats someone as a child, 20 years later, as a pediatrician, 20 years later, that person who they've remained friends confides in him about some abuse. That doctor has a relationship. I mean, you're seeming to convert any relationship of friendship or trust into a legal reporting requirement. And the bounds of that, if you go that direction, I don't know where you stop, other than you say, well, there's got to be an end. But if there's just got to be an end in the view of a prosecutor, the statute's unconstitutionally vague.
I suspect that there's some point where a juror could decide whether or not the teacher was a teacher, or whether the teacher had reason to believe that this harm was present. But as a matter of law,
That's not the triggering. The trigger for the statute at all is that there is, well, that there's an obligation. That's not a jury question. That's a legal question.
the student in this case is not a 20-year graduate. She is still a student.
What about a year later? Would that be okay?
Yes, if she's still a student, and she goes to a teacher because she trusts that teacher.
College student? If she had become a college student. She's graduated from all the high schools now. Now she's a college student. Still good?
Probably not. No, well,
You just
actually,
made that up. I mean, give me a reason for that. Why college and not high school?
actually, I'll change my answer because she's still a student,
Professional student?
a professional
No,
student.
I mean, professional student, still good.
Sure.
15 years later, she's in grad school,
Yeah.
still good.
Well,
enough.
we
She goes
have-
back to her
and-
best friend, high school.
We have lots of cases where reports of abuse come out in a belated, attenuated fashion, and granted, they become less tenuous, but let's keep in mind the sort of preventative, prophylactic nature of the legislation here, which is to stop it before it happens. There are others in danger here. In your situation, Your Honor, I'm not so sure there are. There's an immediate threat here, and And the teacher knows it. She says, I don't want to talk about this. I could lose my job. Which sort of brings us into the second element of the second question that the court asked, which has to do with mens rea. And to try to get to that somewhat quickly here, I'd like to simply submit that this case is more like Bryan and Roby than it is like Ratzlaff. This behavior is more like filing the serial numbers off of a stolen gun than like a barber or a mechanic trying to make a few extra bucks at tax time by getting creative with the tax code. There's inevitably some danger involved here when there's a report of known or suspected abuse. There's no inevitable danger. It's not necessarily nefarious. If my accountant and I have a few exchanges about the meaning of the tax code, I will say that neither the state nor the trial court dealt with this willfully element of the offense, and it is an element of the offense. It must be given effect, and I would simply ask that the court adopt the meaning of that the courts in this state have traditionally done, meaning that the defendant intended to do that which she was not supposed to do, and that it not be raised to a height where she also has to know all the details of the particular reporting requirement. Again, I think that would subvert the intent of the legislature.
Would you agree, counsel, that the statute on its face requires the reporting of, among other things, lawful sexual activities?
Yes.
And you think it would be inherently nefarious that everybody would know that if they find out that somebody who is of the age of consent has entered into a lawful sexual activity, that it's inherently nefarious not to go tell the government about it?
It's not lawful for the teacher. The teacher who
I'm not
engaged.
talking about teachers. I mean, it doesn't have to be a teacher. The way
Or
child is
parapro,
defined
yeah.
in the statute, the way sexual abuse is defined, it would include a 17-year-old having a perfectly lawful and consensual sexual relationship, would it not, with someone more than 5 years older than them?
With whom?
With
Somebody at
anyone.
the school?
Anyone more than 5
That's
years
not, that's nefarious, yes. That's my answer. That's the way I read the statute. Yes. Unless they're married, unless they're related in that way. The legislature does not want teachers.
No, not teachers. I mean, you have to report.
Janitors?
No. You have to report if you know of the child and the parent, or the child and anyone.
Well, that's true.
Okay,
yes.
so just Blackwell's question is, the 17-year-old having sexual relationship with a 22-year-old, let's say they are married.
Oh, outside of the.
Let's say they are married, because in Georgia, they could be married.
I apologize. I
Okay,
misunderstood.
So the 17-year-old and then old are married, but the way the terms are defined in the statute, that seems to be reportable. So so the teacher is obligated. She went to the marriage, they talked about the wedding night.
No, I don't think
and-
that's reportable.
Why?
Because that's not prohibited or nefarious behavior.
That's not what the statute doesn't use, prohibited or nefarious. It uses sexual activity and defines children by the age of majority.
She goes to her physician and says, I just got married, my new husband and I are sexually active, and I need a prescription for contraceptives.
Yes.
Now, ordinarily, that would be a privileged doctor-patient communication, but this statute purports to override every privilege except the privilege of clergy. So it would require the doctor to go report her and her new husband to the government.
I must confess, I honestly didn't get that out of the statute, but if that's the way it is, as applied to this case, I don't think it works that way.
Well, where does the connection between student and teacher, where is it broken? Where would that relationship end in your example, Mr. Hickson?
It would end when the student is no longer a student, or there are no longer students who face the danger raised by the report. The coach needed to be reported. That's the state's position. Thank you.
Thank you. Mr. Cawthorn?
Thank you. I just want to address a couple of the state's arguments. It appears that the state is conflating what is a legal activity with what is an illegal activity. Not reporting child abuse is not an illegal activity. It is perfectly legal for everyone in the state of Georgia to mind their own business, except for the 15 categories of people. And to answer your question, Justice Hines, with regard to when does a student-teacher relationship end, the student-teacher relationship ends when that teacher no longer attends to a child pursuant to their duties as a teacher. It ends when that teacher can't give that child detention anymore. It ends when that teacher can't write that child up. It ends when that teacher can't even report the abuse to the principal because the principal themselves has no power over the child. That's when it ends. It's a bright line. When does an emergency room physician's duty to a child who he set their arm end? It ends when the physician's no longer treating the child. When does a counselor's position end with the child? It ends when that counselor is no longer counseling the child. When does the volunteer at the Pregnancy Resource Center's duty towards the child end?
Let me ask you that. I mean, I understand your bright line, but I want to make sure it's not too bright. Let's say the emergency physician has set the child's arm and the child comes back 2 days later and said, you know, there's something I need to tell you. Does your bright line hold true in that instance?
I think it has to, and I'll tell you why. I think the day after graduation, I think the day of graduation, I think it has to, because otherwise you're allowing the potential victims to dictate the terms. Here he talked about my favorite teacher. Well, why is every non-favorite teacher, protected?
What if the doctor said, during the course of treatment, what if the doctor asked, how did this happen, and expressed some doubts about the answer given, and then afterwards the patient comes back and says, you asked me and I didn't really give you a truthful answer. Really what happened was, and then they disclose some information.
I think it would have to depend, to be honest with you, on whether there existed an ongoing fiduciary duty between the doctor and the child as a patient. I mean, I know that you're cutting it very close with the 2 days, but the reality is it does have to stop sometime. And I believe it stops when that person is no longer professionally involved with the child. It becomes a discretionary duty. Now, does the doctor maybe have a moral obligation to report it? Absolutely. But does the doctor have a legal obligation that could subject that doctor to a $1,000 fine or 12 months in jail if she doesn't report? Well, then I think probably the answer is no. I think once the treatment is over, it's over. Once the student is no longer the student, it's over. Otherwise, there's this ongoing, continuing duty that the state wants this court to find that becomes nebulous, and I would argue unconstitutionally vague, because then no one knows when it stops.
I guess the last question, would that communication 2 or 3 days later be protected by doctor-patient privilege?
That'd be a very good way to analyze whether the duty would apply. That'd be a good way to look at it.
I want to thank both sides for your presentation. It'll be a big help to us in rendering a decision on the matter. As far as we